And I have an intro for Sam and Matt, if that's all right if I read.
Sure.
Okay, amazing. Good evening, everyone. Thank you so much for being here. My name is Lucy Resar, and I'm a program coordinator at Pennsylvanians for Modern Courts. And I wanted to thank you all on behalf of Pennsylvanians for Modern Courts for joining us today, and thank you to Sharon and the Quarryville Library for hosting us. And if you have the chance, I'm going to put in the chat a questionnaire that we have that helps our funding. So if you could fill that out, that would be really helpful. And for those of you who don't know, I'll provide a brief intro to PMC. We are a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is afforded fairness, accessibility, and respect. And for 35 years, we have worked to educate all Pennsylvanians about the courts, how to navigate them with confidence. And we aim to provide resources to make that possible for all residents of the Commonwealth. So tonight we won't be providing legal advice, but we hope that this presentation is an informative and educational experience for everyone here. And we are very, very honored to be joined today by Matthew Samley and Samuel Mecum from the Apple, Yost, and Zeev firm. I hope I'm not butchering too many last names there. Matthew is a partner of the firm and focuses his legal practice in the areas of bankruptcy, real estate, business transactions, and estate planning and administration. He is also on faculty for the Harrisburg Area Community College and frequently presents at professional educational programs on various legal topics. Sam has been engaged in the private practice of law in Lancaster County since 1974. His work is now concentrated on estate planning and probating wills, landlord-tenant, real estate, and civil litigation. And he's also co-hosted annual seminars on landlord-tenant law for 15 consecutive years. So we are really, really extremely thankful to both Matthew and Sam for being here and sharing their extensive knowledge. We hope you all enjoy, and thank you again for tuning in. And now I'll go to the 19th slide for you all.
Good. Well, it's still not quite there yet.
Okay, sorry, I don't have the numbers up on my.
There we go.
Right here?
Right there. Perfect.
Amazing.
A few introductory remarks. Pennsylvania has a 1951 statute called the Landlord-Tenant Act, which interestingly does not define the word landlord or the word tenant. There's a lot of inheritance we have from jolly old England, which is where, frankly, you get the name landlord. Is lord of the manor, the man, the person who owns the property. And you, the tenant, the word tenant comes from a Latin word having to do with hold. You're someone who temporarily holds or possesses real estate of another person with or without payment of rent and with or without a written document, which we call a lease. As you can see from the pictures on the screen, yes, renting a house or an apartment is a hugely significant decision, and the law takes very seriously any efforts on part of, say, the owner, landlord, to dispossess the person who, after all, that person and his or her family are living in that space. Let me read a definition of what a lease is. From a Pennsylvania Superior Court decision in 2010, a lease embraces any agreement, whether express or implied, which gives rise to the relationship of landlord and tenant. The existence of the landlord-tenant relationship is a question of law for the court. A tenant is one who occupies the premises of another in subordination to the other's title and with his assent, express or implied. The agreement may be in writing or in words, and the reservation of rent is not essential for the creation of a landlord and tenant relationship. When the earlier slides that we quickly skimmed over mentioned things like the Pennsylvania Superior Court, Commonwealth Court, and Supreme Court, but the kind of courts that provide the day-to-day fisticuffs, if you will, in the arena of landlord and tenant are what they call the MDJ level, the Magisterial District Judge Courts. And there are something like 19 of those in Lancaster County. And the minor judiciary or small claims court is what we call that, are occupied by people who do not have to be lawyers by background. Now, we have maybe 6 or 7 out of the 19 in Lancaster County are trained lawyers in that position. Could you advance the slide, please? And as an initial construct, it's a little awkward to start with discrimination prohibited, but there are laws separate and apart from the Landlord-Tenant Act, which regulate the landlord and tenant relationship. Among those are the Pennsylvania Human Relations Act and the Federal Housing Act, which prevent discrimination based on, as you can see there, race, color, age, religion, national origin, sex, identity, sexual orientation, disability, and familial status. And one thing that it doesn't mention is the training of support animals or the possession of an emotional support animal. That's a whole other thing that appears in Pennsylvania Human Relations Act. A person, it doesn't have to be a dog, can get a certification from their doctor that they need to have an emotional support animal, and the landlord cannot evict the person, say, because there's a no pet clause in the lease if they in fact have the certification of the emotional support animal. Pennsylvania Human Relations Commission vigorously enforces the anti-discrimination provisions of the law, which are applicable even to non-professional, non-commercial landlords. If you have a house with 1 to 4 other units in it and you rent it out, you, individual landlord, are subject to the restrictions of the federal housing statute and the Pennsylvania Human Relations Act vis-a-vis discrimination. And by the way, that familial status means you can't say, well, sorry, you can't have children living here, or you can't have more than 2 kids. I've had in the past property managers who loosely discussed those kinds of issues with their tenants and gotten into trouble, where if they had just said, you can't have more than 4 people living in this house, that would have been one thing. But one of them said, well, 3 kids, that's too many for the number of bedrooms you have. And next thing you know, they're getting a letter from the Pennsylvania Human Relations Commission saying that thou shalt not do that. And I don't want to get too far into the weeds on it, but just keeping in mind that there are laws prohibiting discrimination on a wide variety of subjects. Next slide, please. It's probably more on, well, there we go. The landlord monkeys around with the quoting of rent to different people, possibly based on race or national origin. The other kinds of things that landlords can do, refusing to permit a person with disabilities to make reasonable modifications to the unit, which, by the way, are done at the cost of the person with the disabilities, putting up, say, grab bars in the bathroom and that sort of thing. But the landlord cannot refuse the permission of the person to do that. And then, of course, retaliating against you for opposing housing discrimination. And they're discriminating against you in the first place, and then you're evicted by your landlord. You certainly go to the Human Relations Commission with a claim of discrimination that way. Skip up to the next slide, please. A tenant has rights in many cases which do not appear in the black letter of any lease. Again, you don't have to have a written lease at all, unless you're renting property for a period of more than 3 years of term, in which case you have to have a written lease for a long-term position like that. You don't have to have a written lease. You have to have some kind of an arrangement, usually demonstrated by the regular payment of rent, that you're occupying someone else's space. And as an implied matter, they, the owner, landlord, must give you quiet possession there. It's called the implied covenant of quiet enjoyment of the property. That is, the landlord just can't come in any old time they want to under the pretense of inspecting or doing this or doing that. Usually what you see in a lease is some sort of provision where the landlord has a right to inspect the property, but only on a certain amount of notice, like 24 hours notice to a tenant. many times people think the law requires that 24-hour period. That's just custom and not written down in black letter anywhere. Same thing, implied warranty of habitability. You rent a property, you expect it to have at least certain basic things relating to safety, sanitation, and so forth. You have to have heat, running water. Generally speaking, an absence of infestation by, say, termites and bed bugs and the like. Although in the case of bed bugs, it sometimes comes down to where they came from. Like who, were the bed bugs there before that tenant moved in, or weren't they? But the implied warranty of habitability does generate a lot of litigation where the tenant has to go through a dance and give the landlord notice, hey, the heat's not working. Then the landlord is given a reasonable amount of time to fix or take care or cure that situation. And if they don't, the tenant could spend the money on space heaters or spend the money on getting the furnace fixed and then deduct that from the rent. Or otherwise, they could later deduct amounts from the rent because they couldn't use half of the house. Half of the house had heat and half of it didn't. You could perhaps pay half of a month's rent, but that gets a little complicated. But it doesn't have to be written down anywhere, and there is no such thing as waiving, at the least like doing away with or waiving the implied warranty of habitability. And then, of course, the third bullet point talks about exclusive possession. That basically means that the tenant is the holder of that property for that limited period of time. Could we go to the next slide?
I have a question.
Okay.
In addition to heat, I mean, now with weather extremes, are we seeing any litigation about air conditioning?
Interestingly, at this latitude, I have never heard a Pennsylvania court ruling saying that the failure to provide air conditioning is the equivalent of a breach of the implied warranty of habitability. Interestingly, I've never seen a case that formally recognizes, at least as a reported appellate level court decision, that the presence of mold per se is a violation of the implied warranty of habitability. I only mention mold because that is the buzzword of the day, and it gets a lot of play and publicity, but not all kinds of mold are harmful and dangerous to people. The black mold usually is. In any case, of course, your question had to do with air conditioning. It's hard to come up with an exhaustive list of defects in a property which our court system has recognized as rising to that level of implied warranty of habitability breach. I do know a serious termite infestation was. They had to worry about whether their feet went through the floor of their house. And certainly running water, probably hot water. The absence of hot water would probably rise to that level.
Yeah, I think if you would have a premises that was designed for a condition like central air in a high rise, that you had no windows to open. I mean, you have to look at the facts of the case, and you leased it on the basis, yeah, there's air conditioning provided, and all of a sudden, that goes out and the landlord refuses to fix it. I would argue that the tenant could make a good case for an applied warranty of habitability. I mean, it may be but again, if it's just like something for convenience, maybe there was a window unit that went bad or something, it starts getting a little fuzzy there on some of that.
Thank you.
And can I also ask a question actually? So earlier in this week, my heat went out in my apartment. So I'm not staying there right now, but the landlord gave us space heaters for the bedrooms. But it's expected to take a while to get the furnace fixed. And I was wondering if they're required to do anything else, if it's taking a while and we can only use, just the bedrooms. I don't know if you had any thoughts on that.
Well, they provided space heaters, and then I'm asking, who pays the electric bill?
We pay the electric bill, yeah.
Say that the landlord ought to sweeten the deal, if you will, a bit more than just providing the space heaters.
Yeah.
Maybe a rent reduction to be negotiated. The other question is whether or not they're acting in a reasonable time frame to get it done.
Yeah.
A lack of heat at this latitude is a pretty serious thing, no question about it. And I would say that, I mean, there's no black and white numbers on this, other than maybe the argument that if you can't use a certain percentage of your house, you know, like 25% of the house is this one bedroom, let's say, then, okay, then maybe you reduce the rent by 25%.
Have to look at like how serious is the infraction that you just can't inhabit the place. Like I remember when I was in law school and there was some plumbing issue and the bathroom couldn't be used in my apartment, and this was in the middle of winter, so the landlord puts a porta potty out in the back of the driveway, and there was 2 feet of snow that winter, and he's like, well, we'll get it fixed. And it's like, I'm really gonna go out there, you know, to use this thing. And then, like you say, Sam, how long do you go with that? Okay, a couple times, okay, and you know, gets into the second week, hey, this is getting old. And now can I really use this thing? And should there be some offset for the rent stuff? Because I'm still paying rent on this and I can't use my place.
There's a rather famous court case called Pugh versus Holmes that establishes this concept of the implied warranty and what you can do about it if you're the tenant. And the repair and deduct remedy is one thing, the offset for percentage loss of use is another thing. But then, of course, you get the slippery concept of exactly how serious of a breach it is that rises, you know, to that level. And again, it's not black and white, but as the slide says, you document it, you for sure make sure there's some proof that you told the landlord, hey, the bathroom doesn't work on the second floor. And then just keep track of the time. You try to work with the landlord, and they should work with you. So basically, if you're a landlord, the only thing you want out of your tenant is a rent check on whatever day of the month there is, and then to hear nothing either from or about the tenant again until the lease is up. But I'm not saying that all landlords are mean and nasty people, but they sometimes have to be prodded into action, and this is a way to do it, is maybe to remind them that there is this thing called the implied warranty of habitability. And then I can see the rest of the slide refers to a tenant having to return the property the way it was, as one of their responsibilities is not to do damage to the property. There's a whole series of discussions we've had on security deposits and what a landlord is justified in doing by way of withholding the reimbursement of the security deposit at the end of the lease. You know, how about repainting the walls? And large complexes, they routinely repaint the entire unit each time there's a turnover of the tenancy. So the need to repaint is not really an element of damage to the property.
Right.
And it goes into way too many weeds for purposes of this discussion we're having right now, as to how a tenant can sue the landlord for not giving them their security deposit back in a timely way. But I think I would get too far into the details to go anywhere further with that. So let's go to the next slide.
And I'm sorry, I have one more, I have another quick question. Is there a statute of limitations on going back? I'm thinking my daughter just graduated and her last year of college was on this house that she rented with a bunch of people. And oh my gosh, that habitation was just a mess.
I would say 4 years, which is the general contract statute of limitations.
Okay.
There are ways where if a property is in really bad shape and there are physical defects to the property that causes someone to like fall through a railing on the porch and get seriously injured, there are ways where you could actually sue the landlord, what they say in tort, for physical injuries and damages. A statute of limitations of that kind would be more like 2 years, but what you're talking about is that's basically a 4-year limitation period.
I'm thinking of the water bill, because we had to pay the water bill and she had like a month where she couldn't use her bathroom or laundry. There was like running water only in parts of the house, but not the part that she was renting.
Well, it's pretty difficult. You're talking about an implied warranty of habitability breach long after the fact. It would still be a 4-year statute, but usually by that time you've already paid the rent, and I don't think that that would be worthwhile to pursue. It would be a small sum of money, and frankly, going to court it costs a significant amount of money, even if you don't have a lawyer, the filing fees alone. I don't know, but I would say 4 years.
4 years if it's, if there's clear indication in the lease what the responsibilities, but it may actually be shorter than that in some cases. I mean, you have to really look at that carefully, but I agree, Sam's comment about, the longer you wait, the credibility of the claim is less for the court. I mean, you have to look at, the court's going to say, well, why did you wait this long? What's going on here? And so, yeah, you have to weigh the costs and benefits looking at that.
Maybe Matt wants to do the landlord's rights.
Okay, so, kind of dovetailing what Sam talked about, and, what is a lease? It really is a conveyance of possession, and and there are contractual rights. And when you have two people, where one is using the property of another, as a real piece of real estate, by default, it is a lease. So we do look at the Landlord-Tenant Act, no matter what we call it. And the landlord generally has rights, not only under the act, but also under the lease. There's no exception for not having a good lease. I mean, that's where you really want to define these things. So the first point there, a landlord can set rules about how the property and common areas are to be used. Again, usually that's going to be defined in writing. You may have a lease, and then you may have rules and regulations attached to that lease that further, regulate the use of that property and so forth. Who uses the common areas? Is the tenant going to pay for any kind of common area maintenance in addition to base rent? Again, usually you see that in commercial leases, shopping centers, etc. You may not see it as much with residential, but again, in apartment buildings, you may have common areas. So again, you have to look at, as a tenant, what are the responsibilities? And the landlord does have right as set forth in those regulations. Landlords are entitled to have keys to the property. And if the tenant changes locks, must give landlord a copy. Again, the tenant has a right of possession, but it's still the landlord's real estate. They have ownership. So again, the landlord does have a right to inspect and so forth, as provided in the lease and otherwise. So landlord needs to, the tenant should just be changing locks and not providing the landlord a copy of the key. Landlords have a right to evict tenant using the judicial system, and again, depending on the nature of the lease and what is or what isn't there, will define those rights of eviction. So by default, under the Landlord-Tenant Act, the landlord has to give what we call a notice to quit to the tenant for non-payment of rent. If that's what it is, it's usually like 10 days or whatever.
10 days is the default provision, unless the lease specifies something different.
Right. So you look at that, and again, that's a right based on non-payment of rent. If there's other infractions of the lease beyond non-payment of rent, then there's usually a longer notice period. But again, that can all be waived by contract. So you have to look at the contract, and we usually advise landlords to keep that pretty short or waive it, because if we represent the landlord, because they don't have to give the tenant that notice right, and especially if there's failure to pay rent and so forth. So is there an opportunity to cure? Well, again, landlord's bound by its own lease. So if there's some opportunity to cure in the lease, you're going to have to provide the tenant that. I mean,
if I may say, frequently leases have a 5-day right to cure, or maybe a grace period, where for the first 5 days of the month, you won't get charged a late fee, but that is not part of the Landlord-Tenant Act. That's just something that is pretty widespread and prevalent, and people get to thinking that that's what the law is, but there does not have to be any grace period built into a lease for late payment of rent.
Now, you could literally have no notice to quit, no notice of a default, and go through the eviction process. But the one thing, that next point, landlords must pursue evictions through the court system. There's no self-help eviction that's allowed. You can't padlock a tenant act, and say you didn't pay and we're locking you out. You can't do that. It's actually very hard to get rid of a tenant in Pennsylvania. I mean, there's a process to go through, and Sam will talk about this later, but you're filing your complaint, you have your hearing, and you're gonna have a hearing whether the tenant shows up or not, you still have a hearing, and then assuming you're victorious, you get an eviction order, then you have to proceed further than that to actually get the tenant out of it at some point.
And the tenant has appeal rights, regardless of the merits of any appeal. They have automatic rights to keep appealing the case through the court system.
Right, exactly. Landlords they usually do require security deposits. It can't be more than 2 months rent in advance on that initial term of the lease. And again, that security deposit, what it's to be used for should be clearly defined in the lease, in my view. Is it for damages? Is it for non-payment of rent? It's not up to the tenant to decide what the security deposit's for, because sometimes they'll say, I won't pay the last month's rent and take it out of my security deposit. Well, that's not up to the tenant. You know, it's the landlord uses that for damages and so forth. And the landlords are required to reconcile that security deposit at the end of the term. And, you know, what are the damages? What goes back to the tenant? What is going to be kept as an offset and so forth? Again, that has to be reconciled usually within 30 days or something like that.
There's a whole statutory dance that we do as far as the landlord has 30 days to present the tenant who has vacated and given a forwarding address, by the way, and turned the keys back in. The 30-day period then starts ticking for landlord to give an itemized list of damages and then a refund to the tenant of the difference. My experience, being cynical as I am, is most landlords seem to think of a reason why the entire security deposit has been blown away by various things, the damages that the tenant has allegedly done. But there are penalties that can be imposed on landlords who play footsie with security deposits. Again, it's too much detail for what we're talking about now, but there are penalties for landlords who overcharge and or don't return security.
Yeah, they may be required like for double the amount of deposit back to the tenant. And the thing is, we do, you know, and I've seen, and Sam has seen in our practice, where landlords don't understand that, you know, damages are one thing, just a dirty place is quite another. I mean, that's not real damage. The courts will look at that, you know, is there a true reading on that security deposit in terms of an offset there, or is it just that the landlord's just unhappy with the way the tenant left the place?
You could have by contract, and a lot of large commercial apartment complexes have it, where you have to steam clean the carpet at the end of your lease. Now, if that's a contract provision that they steam clean, then they have to do it. And if they don't do it, it would be legitimate for the landlord to deduct that from the security deposit. But if it doesn't say that, then dirty carpet is not, in my opinion, damage to the unit.
Yeah, or a dirty stove or kitchen or something. Personal belongings, you know, again, it's a good idea in the lease for the tenant to be reminded that they should insure their own personal belongings. If that place burns down, it's really not up to the landlord's insurance to cover the tenant's personal belongings. And I think a lot of tenants don't understand that or forget that. Something happens catastrophically, maybe there's a theft, maybe there's something else going on. Again, usually the tenant, if they don't have insurance, is going to be out on that loss. So
there's a whole other relatively new section of the law. For many years, there was a hole in the law having to do with what happens if a tenant vacates but leaves a bunch of their stuff behind. And the landlords always used to just take it out to the dumpster and throw it away, but they were not obligated. I mean, excuse me, they were not really authorized to do that. It still remained the tenant's property. But then the legislature, in its infinite wisdom, tightened up the law so much that they have put, to me, unduly onerous requirements on part of a landlord. A tenant who, let's say you've evicted them through a process, they owe you rent, they've beaten you out of the rent money, and the tenant owes you several $1,000s. After they leave, you, the landlord, still have to give the tenant a written notice that they have 10 days to notify you whether they want to come back and get their TV set and their entertainment center and whatever they have left behind.
It's still considered the tenant's property.
Still,
and I've had this case a couple of weeks ago. You know, a client has a multi-unit apartment thing, the exact same thing happened, and they're ready. Tenant didn't pay rent for months. They finally got the eviction, but the stuff is left there. They have to go through that process and they're ready to relet the premises to another party who's ready to go in there, and they're stuck until they go through the process, store the belongings, and go through that whole abandonment thing.
Well, there is a statutory dance in this section too, where you give the landlord, give the tenant a notice that if you don't notify us within 10 days, we're going to dispose of your stuff as we see fit. If the tenant simply calls on the telephone and says, I want to come and get my stuff, then the landlord has to give them another 20 days, basically a 30-day period from the beginning of the notice to the end, to actually let them come and retrieve their belongings, which the landlord is not obligated to leave in the same.
Yeah, they can store it in a
store
separate
it
place.
Somewhere else. But anyhow,
Yeah,
this is
it's really, this slide says what are landlord's rights? We should really call it landlord's obligations, because there's just a lot there as well. Next slide, please.
maybe that's obligations.
Oh, there you go. See? So yeah, we talked about some of this: fit and habitable premises, safe, sanitary, accessible, up to housing codes, repairs completed in a reasonable time. Now, again, you may have in the lease like certain repairs versus replacement items. You know, you don't want the landlord to have to put every light bulb in an overhead fixture every time there's one that's burned out. I mean, and maybe you have repairs up to a certain dollar limit as the tenant's responsibility or something like that. And certainly if the tenant's damaging the place, yeah, it's the tenant's responsibility. Common areas, again, the multi-units are typical that the landlord,
Sorry.
and Sam is fooling with my screen.
Sorry, I just did something dumb.
Yeah, I have to click the,
Which one?
I have no idea.
This guy? No.
There you go, you got
There
it.
you go.
Okay,
I was trying to clear the screen so we could read everything on there.
there you go. And safety, cleanliness standards the landlord must provide. Again, in that blue box there, this gets back to the implied warranty of habitability. You know, drinkable water, functioning bathroom with toilet, showers and tubs that work, and so forth. You know, definitely the big things today we look at is smoke alarms, safety items are paramount. And you know, a place that's in habitable condition. You know, the exterior walls, the roof are in good shape, no problem. Notice it says heat during cold months, but no cool air required unless written in lease, according to this slide. So there you go.
Well, I've always said that. You know, I grew up in a house without air conditioning, so I'm biased, I guess.
There you go. Okay, next slide, please. Yeah, lead paint. So, you know, this is a big thing, especially in Lancaster County, older places in the city here. Before 1978, there was lead paint used quite prevalent in houses and buildings and so forth. So the tenant must be made aware through a lead paint disclosure, an EPA pamphlet about the danger of lead paint. And that is extended now to in the landlord-tenant area, not just the sale of a home, but in the landlord-tenant. So it can be a problem. Lead pipes are another concern. And I think that a lot of municipalities are really starting to crack down on this. You know, are there lead pipes in the home? They want to know about it. You know, how are they going to be remedied and so forth and dealt with?
You touch on an example of a law other than the Landlord-Tenant Act itself that regulates the landlord and tenant relationship. There are a lot of local ordinances having to do with smoke alarms, for example, as another. There are rental ordinances now in various townships like Manheim Township where you have to register your property as a rental property and every so often have it inspected by as they do in Lancaster
Columbia is another one, Lancaster City, you know, and that's a good point in that Pennsylvania, as you may be aware, you know, we have a fragmented municipality system. So we have multiple boroughs and townships and segregated government and ordinances, et cetera. We're not on a county-wide basis. So in Lancaster County, you've got, I don't know how many boroughs and townships, but
60
just in this county, and all of them have different ordinances that regulate the landlord's responsibilities in those areas. So you have the Landlord-Tenant Act, but a lot of it comes from these municipal ordinances here. So again, you've got to be very well aware of what's going on there. Maybe you reach out to the municipal officers. You know, they're probably going to do an inspection anyway. Make sure you're aware of what's going on. Have a good rapport if you're a landlord with those people. you know, so it's not adversarial. Usually they'll give you a slap if there's a problem, a notice, try to get it resolved and so forth.
On that slide, it says if a tenant tells the landlord a smoke alarm is broken, the landlord has 72 hours to replace it. I don't know where that
I
comes
have
from.
never heard of that.
It's not in the Landlord-Tenant Act itself. I can tell you
No,
that.
unless that's a particular municipal ordinance, but I don't know what that
I
would
mean,
be.
it makes sense to have something like
Right,
that, but
right.
it's not a generic statewide
No.
law, that thing that I'm aware of.
Yeah, not at all. Next slide.
There we go.
So landlord cannot do the following to a tenant. So you can't distress or distrain a tenant's property for failure to pay rent. You can't like seize it, sell it, and offset the rent somehow. That's illegal. Shut off utilities, padlock the tenant out. We talked about that. Self-help evictions are not allowed. Harass a tenant, you know, and or threaten under duress or something like that. That would be impermissible. And just enter the property without notice, except in an emergency, and just say, I'm giving a surprise inspection. I'm just going to walk through the place. Generally, that would not be allowed. For assistance animals that are legally permitted there, medical prescriptions, you can't require deposits or extra things for that. And you can't and if the building, and a lot of people don't understand this either, you have a contract as a tenant with your existing landlord. If that landlord sells the building, that contract is assumed or assigned by the new landlord. It still exists.
Yeah, it runs with
It just doesn't cancel. I've seen landlords try to put language in leases that somehow the lease is null and void on a sale of the building, and that's not really enforceable. If you have a term that continue, that's in the lease. So again, if you need to take repossession of the property, as this slide says, you need to go to court. You have to go through the judicial process. Can't use self-help. Next slide, please. The lease agreement. Now you can't see it that well here. This is a standard form. I'm seeing this. It's not the Pennsylvania Association of Realtors. This is the Landlord Association of Pennsylvania form. And it's very, very important for both parties to read this lease carefully and negotiate it. Leases in Pennsylvania that are consumer for personal, family, household purposes must be in plain English under the Plain Language Consumer Contract Act. That's a 1994 law, and you can't use legalese, you can't use complex language, things have to be put out and so forth, but you do need to read it carefully. And the conditions of that lease, not only the financial commitments, but the other commitments in terms of repair, maintenance, how many occupants are allowed in the premises, you name it, has to be in that lease agreement. So next slide. So there you go. A lease is an agreement between landlord and tenant. Okay. So again, it is a contract. And you need to make sure you fully understand and agree with its term before signing. Okay. Sam said leases can be oral or written. They don't have to be written unless they're at least 3 years in term.
That slide is incorrect when it says more than 4 years. It's more than 3.
More than 3 years, yeah.
But
that's
nonetheless,
a typo.
to be enforceable, it must be in writing.
Yeah. An oral agreement is technically month to month. Lease must be written in plain language. And again, that comes to that Plain Language Consumer Contract Act, no fine print. And then again, once you have a contract, those are contractual terms, and you can only modify it based on what the contract says. Maybe they both parties have to put the modification in writing, or certainly they have to agree to a modification. Can't be unilaterally changed.
One other thing about this slide, it says the definition is to occupy and use a property for a certain amount of time, quote, in exchange for rent, end of quote. I want to emphasize it doesn't have to be an actual rent payment made in order to call an arrangement a lease or a landlord-tenant relationship. Maybe they're just paying the utilities, or
Yeah, well, it depends. That rent is kind of not the best term. Yeah, payment, and there's got to be consideration. A contract requires offer, acceptance, and consideration. A bargain for exchange of something of value. So as Sam said, that could be just hey, you're paying all my utilities, you're gonna pay my expenses.
Or they're living there from month to month and they're mowing the yard and taking care of the roof or the maintenance or whatever, anything like that. So it can get pretty far out there as to what actually constitutes a lease.
But it's really a right of possession for a certain time period, because if it's not, and this is kind of beyond the scope of our seminar here, it could just simply be a mere license to use something that would be revocable by the landlord to say, you're out of here. But again, if you don't know what else to call it, it's a lease. Next slide. So what does it contain? These are the basic provisions. Again, what is the term of the lease? What are the dates? So that's important. What is the move out date, the move in date? What's the effective date of the lease? Who makes the repairs? And that should be, again, defined very carefully. Repairs versus replacements. For example, like, is the tenant required to keep the HVAC system serviced? Is that a repair? What happens if there's a problem with that system? Should the landlord be the one repairing it? For the landlord to repair it, is there a condition that the tenant has to maintain it? If the tenant's not maintaining it, can the landlord argue that, that was breached? So you really have to define that carefully. Smoke alarms, if they're battery powered, if they're hardwired, who maintains those? Probably the landlord is going to have to do that. Visitors, again, when do visitors become de facto tenants? Like, they're almost living there and they're beyond the occupancy. It says 4 people can occupy the premises, use it. Well, and then you have Joe Schmo relative like staying there for 2 months. Could that be a problem?
Frequently, a lease will have a blank space in it for how many occupants there can be. And I've seen some older form leases that say blank adults and blank children.
Yeah.
You just don't say anything in the lease about how many children can be.
Yeah. Watch, and that's a good point. Watch lease forms. People are so hung up on forms. Forms are guidance. But if you buy a lease form like at Staples, that's generally used like any state, anywhere, it probably doesn't comply with our state's plain language law. That's number one. And like Sam said, it probably violates our own Human Relations Act and some of that other stuff there. So again, you've got to be very, very careful with forms. Entering. Must the landlord provide the tenant notice before entering the property? And what are the parameters of that? And utilities, good residential leases have almost like a checkbox type of thing with who pays what utilities. Here's electric, here's heat. That makes it very nice. Then there's no question as to who pays for it.
Generally speaking, the landlord is going to be paying things like a water and a sewer bill because if they're not paid, they can become a lien on the property that the landlord owns. Although you could have something in the lease that calls for the tenant to reimburse that, you're generally not going to have the water bill in the name of the tenant.
So Sam, can you require a tenant to use certain service providers for utilities?
I was just in the news recently where a multi-unit landlord has required all of its tenants to have an $80 a month Comcast internet hookup. And somebody who lives out there objected because they have a cheaper already existing internet service. And one part of the Landlord-Tenant Act, even though it was originally written in 1951, was updated, among other things, to say the landlord can, in a multi-unit lease situation, cannot limit who the tenant can go to for cable TV. It doesn't say internet, though. They haven't quite gotten up to the 21st century, but nonetheless, there is a piece of the Landlord-Tenant Act that says a landlord may not restrict in any way a tenant in a multi-unit dwelling from acquiring and obtaining whatever goods and services they choose.
So the question is, and the courts are wrestling with this a little bit, like if the landlord says, well, here we factor in this $80 charge in your rental for Comcast, and you say, well, I want Verizon. So you probably have a right to get Verizon, but then the question is, do you also have to pay the $40 fee for Verizon yourself? Or does it allow you to say, hey, landlord, I don't have to pay the $80 Comcast thing you're sticking me with as part of this bargain?
If I was 30 years younger, I'd take that case, because I think that requiring somebody to have the $80 service when they already have a $50 a month service is the same thing as, quote, restricting in any way their ability to contract for goods or services. But we digress.
Yeah, but it's hot. This is that's a
That's
recent
current.
issue that has come up, and we're gonna see that more and more. Late charges, again, does the, Landlord-Tenant Act doesn't talk about, oh, late charges are, blah, 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 blah. That's gonna be in the lease, so you wanna look at that.
As a matter of law, they can't be unreasonable, but nobody knows exactly what that is.
Yeah.
But $50 a day is probably too much.
Yeah, right. Yeah, if you have $300 a monthly rental and you're charging 50 a day for late, probably egregious. Who's responsible for snow removal, for leaves, for trash, that type of thing? Again, it makes a big difference if it's probably a multi-unit versus you're renting a house, and basically it's like your house. You probably, they say possession is 9/10 of ownership. So, a lot of times the tenant's going to be responsible for a lot of basic house, cleaning and repairing and
Light
maintenance
bulbs,
and maintenance. Yeah,
yeah.
exactly. And then, of course, every good lease, you want to make sure there's provisions regarding renewal or terminate. Be careful with termination provisions. Does the lease somehow automatically renew unless some party opts out not to renew? Or is there an affirmative obligation to renew it for another term? Well, then you got to put it on your tickler and make sure you don't blow that deadline. So you want to look at that carefully. Or is it just, that's it? You got a 1 year and that's it.
Most common phenomenon is you have a lease for 1 year, but after that 1 year, then it rolls over from month to month, which basically means either party could give the other one simply 30 days notice. Okay, the lease is up, and that's that.
Yeah.
If you're a landlord, you want the flexibility of a month-to-month lease. And if you're a tenant, you don't have much of a right other than to occupy that space for 30 days.
Yeah, and as a tenant, you've got to watch what we call holdover, that you're holdover beyond the term of the lease. Because if you do that, many leases have basically, akin to almost penalty provisions. You don't usually put penalty provisions in contracts, but they'll have provisions in there that like the rent will be 150% of the current rental, because you want to discourage the tenant from doing it. But as long as they remain in possession, they have an obligation to pay the landlord something. So there you go. Next slide. So the fine print on security deposits. Here you go. We've talked about this a little bit. This is kind of getting into the weeds a little bit. First year of the lease, 2 months rent. Technically, if it's a longer term lease, technically the security deposit should be exceeding 1 month's rent. And then if you're talking about long-term leases, not leases that renew, but like multi-term leases, like 3, 4, 5 years out, really a long term, then landlord may be required to put security deposits in escrow, interest-bearing accounts, and so forth. But the tenant has obligations too. The tenant's not going to get any security deposit back legally, technically, unless they provide the landlord a forwarding address, technically in writing of some sort. Can't just like tell the landlord on the way out, oh, by the way, I live at such and such. Technically, under the statute, that wouldn't be proper. But again, where do you find the tenant? Landlord has 30 days to return it if there's any security deposit left, showing an itemized list of deductions for damages.
There have been cases where tenants have been able to sue landlords under the unfair trade law, the consumer protection statute, which does apply to the landlord-tenant relationship, where a landlord is just fraudulent in their statement of damages, and they're not giving the money back because they did this. And if you can prove that the landlord maliciously misrepresented that, you could sue actually for treble damages and attorney's fees in the appropriate case.
Yeah, that law is called the Unfair Trade Practices and Consumer Protection Law. And it is a consumer fraud statute, consumer protection statute, and it's got teeth. And a lot of tenants use that. They use it as a defense, and they use it to counterclaim against the landlord, and security deposits are a good example. If the landlord is misrepresenting the nature of those damages and falsely indicates certain things in writing, that tenant can get some good relief there. Next slide. Okay, waiver of notice to quit.
It says notice to quit.
QUIT.
Hey, we didn't write these.
There you go. But it's important that tenants be aware of these things. Again, the landlord does not have to provide a notice to quit to the tenant. They can waive that in the lease, okay, to give notice of eviction. So the landlord could take immediate legal action without even notifying the tenant in advance that they're in default. So
Which is rather remarkable. And
It
when
is
you think about all the protections there are.
it's amazing that, especially in residential leases, that they would allow a waiver like this. I'm kind of surprised.
Now, if you're the landlord, and I represent a lot of landlords, you don't want to have to give a notice to quit because that gives them that much more time to occupy
Right.
the premises. And it is waivable. I have had cases years ago where a local magisterial district judge said, I don't care that the law says it, you got to give them notice. But
Yeah.
as a matter of law, there's a checkbox on the eviction form that says notice
Well,
is not required under the lease.
And
or it's
again,
waived.
watch those form leases, because, you know, landlord may be stuck with some notice to quit. I've seen older lease forms that have like 30-day notice to quit clauses and beyond. There's 60 days. It's like, why? Well, it was, you know, then you're going to be bound to it if you signed off on it. Next slide. So the lead paint disclosure, lead-based paint hazard reduction act, Title 42, I think it's the United
It's
States.
supposed to be
Code.
USC,
USC.
meaning United States Code.
Yeah.
Yeah, it's a
That's
federal
law,
statute.
right? EPA approved pamphlet. That's what I referred to before. Any houses built before 78, premises there, all leases are applicable there. And if you don't comply, you know, you can see the penalties. There's $10,000 civil penalty, an injunction against the landlord to prevent the landlord from leasing out that property until compliance is made.
And there is an actual booklet that's published by, who is it, HUD or something? The
Actually,
federal,
the EPA.
the EPA
Yeah.
publishes a booklet that if you're a landlord and say the city of Lancaster and you have buildings that predate 1978, you're supposed to hand out that pamphlet or
And you can
brochure.
get that all online. There's the link there, and you can just do that. So there's really no excuse for a landlord not to do that. It doesn't mean you have to, unless the municipality requires it, but for purposes of the federal law, all of this is disclosure. This isn't remediation. This is, I mean, the place might be full of lead paint, but the only thing the federal law requires is notify.
If that was discovered after the fact, the tenant, of course, would be justified moving out,
Yeah,
vacating the
Yeah,
apartment. But
exactly.
that's a whole other thing.
Exactly. Next slide. There you go, Sam. I'm going to turn it to you.
Well, there's a reference to resolving issues outside of the court, but the slide is talking about what a tenant can do if there are defects, possible violations of codes and such as calling local housing inspectors to get them on the side of the tenant is a good way to go. That repair and deduct reference is from the Pugh versus Holmes case, where if a serious defect, okay, the lack of heat or no running, or the toilet exploded, and
Yeah.
to the extent that the landlord is dilatory in getting around to fixing some major item, the tenant would be within your rights to repair or replace the item and then deduct that from the rent. It says cannot exceed the monthly rent amount. I'm not sure what that is literally correct. You know, if you had to pay $2,000,
Well, maybe you can't deduct more than you receive. I don't know.
well, the overall amount of rent,
Yeah.
maybe, but not just 1 month, that it would
Right.
have to be beyond that.
Well, again, this is just a suggestion for the tenant to try to resolve it, I guess. And it's good advice, I suppose. You know, you should take pictures of damage. You should do that type of thing. When you, as a tenant, begin your tenancy, you ought to take pictures. You ought to take pictures of everything, because you don't want the landlord to come back at the end of the time. Oh, I'm deducting the security deposit. This is damaged. And then you say, well, wait a minute, I took pictures to begin with, and we noted that this was already damaged. So,
in a perfect world, there would have been a walkthrough at the beginning of the lease, and then some commercial landlords do that routinely. There's a checklist that the tenant says, yes, they went through and this is okay and that's okay. And they identify the condition up front, which is much better than having.
Turn on,
something
turn
else.
on, just like you would in buying a house, turn on the systems. If there's a heat unit, turn the heat on, check the lights, make sure everything works. I had one where they, landlord said there was heat in the premises, and it turned out there wasn't. And he said, oh, but you can just turn the stove on. And so it was a small studio apartment, and you can just turn it on because the heat will trickle in from the other apartments. Well, no, that's just not so.
Next slide, please. Yeah, okay, a neutral third party could assist in the resolution, but quite frankly, in our experience, the landlord and tenant issues need to get resolved way too rapidly to allow for what would otherwise be a let's all sit down and talk together. There are certain leases called Section 8 leases through the federal government and the Department of Housing and Urban Development, where the landlord must sit down with the tenant to discuss issues that involve breaches of the lease first before they evict them. And yes, I agree, you can solve many problems outside of court. But frankly, mediation is something we don't generally have or see particularly often, not in a landlord-tenant relationship. Maybe in the case of buying real estate, a real estate sale agreement, rather than suing, it's better to mediate.
Right, possibly with a commercial tenant, like a store that's been there for 20 years and they had some issue there. Maybe, but alternative dispute resolution like mediation in a residential lease, the landlord just wants to get rid of the tenant, and the tenant probably doesn't want to stay there anyway. So,
And it is appropriate that we emphasize there's a huge difference under the law between a commercial landlord-tenant relationship and a residential one, which could be the subject of a whole other seminar on that alone. But it would be in commercial leases where you'd be much more likely to see a mediation / mandatory arbitration provision to try to resolve the matter, because court costs everybody money and takes a long time. And if you can avoid it, then you do.
Yeah,
So,
we would recommend not having in residential leases a mediation or ADR clause. I mean, I think you're just trapping yourself. If you're a landlord and you buy a form lease and it's stuck there and you didn't see it, it's just going to be delay for you to evict that tenant.
because more often than not, the tenant is the one who is looking for the delay, and it's very easy for the tenant simply to continue to file appeals. And they don't even have to have a reason or a basis for filing an appeal,
doing it over
because they automatically have a right to do so. And if one of those rights is we have to go through mediation first before you get to the other series of time lags, well, then the system is out of control that way. Next slide, please. We may be running short of time.
We're at 7 o'clock now. I don't know if you want to wrap up with going to court. I can skip ahead to that.
Okay.
Or it's totally whatever is up to you all. I can also send these slides out to everyone so they can review the ending ones on their own, whatever you would prefer.
Fourth thing would be good, just as a summary of that, I guess.
Okay, I'll skip ahead to there.
Probably just MDJ.
Well, we have discussed this. The going to court part is something the landlord can't just lock the tenant out. Throw their stuff out on the porch. There is no such thing as self-help eviction in Pennsylvania. The usual place where a landlord goes to start the process is the magisterial district judge, or MDJ level, where there is a one-page checkbox complaint, which results in a hearing scheduled within 10 to 15 days thereafter. You could put the next slide on. When the landlord sues the tenant by filing the eviction action at the MDJ, civil suit, 2 litigants, yes. Well, in the landlord-tenant context, the liability would be for usually not injury as such, not physical injury, although it could come up maybe with a mold claim or something like that. It's usually a matter of, did they pay the rent or didn't they? Have they, has the tenant materially violated or breached the lease in some other way, like had too many people living there? They have a pit bull dog they weren't supposed to have. They've damaged the property in some significant way.
You do have a right to counsel. I mean, not like a public defender, but you can certainly bring an attorney in.
Well, the civil suit, you do have a right to an attorney, you also have a right not to have an attorney. But the preponderance of evidence standard is to differentiate this from criminal law, where a conviction of someone charged with a crime must be beyond a reasonable doubt. So it's just, is it more likely than not that A owes B money for a reason relating to the breach of the
Just
lease?
tipping those scales a little uneven there, and whoever has the bigger weight wins.
Next slide. Well, it says rulings are binding but may be appealed. Of course, at the MDJ level, there are two things that are involved with an eviction case. One is possession, and the other one is money, either rent or court costs, and sometimes attorney's fees can be included if it's mentioned in the lease that the prevailing party is entitled to be reimbursed their attorney's fees, then that can be part of the money damage element. But at the MDJ level, an adverse judgment relating to possession of the property must be appealed within 10 days to the county court. That's a pretty short time period, but it used to be 30 days, and landlords complained about that and lobbied the legislature to make changes and make it more like 10. But the 10 is just the start of the appeal process to the county court. There's references to court staff. Court staff many times, and particularly in the courthouse, are asked for legal advice. People are coming in to file their own papers, and there's a big sign over there that says, "We do not give legal advice. We're just a prothonotary." Same thing at the MDJ level. The secretaries are not authorized to give legal advice, but they're commonly asked to do so. They say you'll have to hire a lawyer. Many people can't afford lawyers, so they proceed what they call pro se, and frankly, that is usually a mistake. Try to represent yourself. Many complications and pitfalls, things you can fail to do on time. You try to file an appeal to county court and you miss a certain time deadline, the landlord can immediately kick your appeal out of court. There's a reference to security. At the MDJ level, I haven't noticed security much.
Not at the
Anytime, but
MDJ level.
the courthouse right across the street from where we're sitting, as a matter of fact, here in Lancaster, it's like going to the airport, going through TSA, and you have to take your belt off, and you can't take a cell phone into the courthouse. You can check it now in a little series of lock boxes. But anyway,
it is a process, and I always say, you really, attorneys there are to guide you and represent you. I mean, it's like, look, you could do your own root canal without a dentist, I guess. It's the same thing. So how far do you want to do it yourself? And the higher up you go in the judicial system, the more complex.
I mean, even a reasonably intelligent, well-educated person just can't possibly have devoted enough of their life to the stuff that geeks like Matt and I do and digest rules and cases. And there are too many variations, and human behavior is complex. And anyway, you just, long and short of it, don't try to represent yourself in one of these court proceedings. How about the next slide? Well, okay, that's true. I call venue is the place where you can sue. You usually are suing in the district where the rental property is located. Now it says Court of Common Pleas is a countywide case. The magisterial district judges have jurisdiction over cases, landlord-tenant cases, but if it involves more than $12,000, that's their jurisdictional money limit, then you'd have to go to the Court of Common Pleas to file suit in the first place, which, by the way, is a whole other animal, very complicated, time-consuming, involves discovery and extreme cost. If you are the landlord, you want to go to the magisterial district judge level, even if you're owed somewhat more than 12,000 bucks.
Yeah, because one of the things is, again, probably you're not going to get paid anyway. The judgment is a piece of paper and it looks nice, you can frame it, but you're not going to collect on it. What you want is eviction. So why go to the Common Pleas for ejectment? Go to the MDJ, get the eviction, and be done with it.
And about 90% of the landlord clients I represent, you ask them, what do you really want here? They just want the property back. They don't really expect to chase down the defaulting tenant for past due rent. How about the next slide? It can't be too many more of these. There we go. Oh boy.
There's still a fair amount left. So I don't know if we want to open it up for a final round of questions and then people can review the rest of the slides, or if there's a final slide you want to wrap up on.
I think we covered it pretty good, Lucy. Why don't we open it up for questions and let the audience have an opportunity?
Perfect. That sounds great.
The vast audience.
Well, my patron did leave,
Okay.
but she left, she stayed till about 2 minutes ago. So she was very interested that.
Well, we can go on and on and on and have probably presented, Matt and I have presented seminars called the Sam and Matt Show. And many times we could take 2 or 3 of these segments and just devote an entire hour to just any one
Different pieces of
Yeah.
the area.
like the security deposit thing is a whole other item. Well, if there aren't any other questions, I could go home and eat dinner.
Well, thank you so much, both of you. I really, really appreciate it. I also got to ask a question, which was amazing. And thank you everyone who joined on Zoom, and I hope everyone has a great rest of their night.
Thank you,
Thanks.
Lucy.
Appreciate it.
Take care.
Okay.
All right.